upat sa July, unom sa June, and sa August, ikaupat na nato sa August kay 3, 10, 17 o 24. Ikaupat. Ya doon na pagitay 31. So lima sa August. So all in all pagkatapos ng August, we shall have finished already 14 sessions, and therefore for 2 hours. This is almost one semester already. This is my offering to my alma mater, because when I finished law, I could not afford to take bar review. Very poor. I could not even buy books. So I have to promise that once I become a lawyer, I give back the blessings I received from the Lord. So tonight, after 12 Mondays where we discuss labor standards, we will now discuss labor relations. So from book 1, book 2, book 3, book 4, and book 5, we skip book 4. We'll come back to book 4 because it's about disability, disease, and death. I don't want to discuss death benefits at this time of pandemic. So we will discuss labor relations today, and I hope that the attendees today will get benefits. I will strive to finish the 28 principles, but as first 3 principles pa lang, mahaba na, no? So all of you who are going to take the bar, I always keep on repeating this. By the way, I have a student, San Beda student, Dean Wagas, si Mr. Husni Ayo, who is Maranao. Are you here, Mr. Ayo? I have seen your name. No?
Yes, USEC. Maayong gabi.
Oh, I'm happy that you. How did you know? No.
I saw it on your post, USEC.
Very good. So you are now in Maranao or in Iligan?
I am still in Manila, sir.
So you're in Manila.
Yes,
we are starting classes tonight, today in
yes, sir.
San Bida, Alabang. So mabuti naman na nagustuhan mong mag-attend dito sa among pinubring mga bar review sa mga dinhi sa among universidad sa Visayas, no?
Opo, sir.
I welcome you. And I hope that pag wala kang klase pag Monday, you can continue to join. No?
Thank you very much, sir.
You are welcome. Assalamualaikum.
Waalaikum assalam.
Okay, so all of you who are going to take the bar, and those who are not taking the bar, I'm also encouraging you to take very seriously Article 13, Section 3 of the Constitution. The Constitution of 1987 was framed by a commission headed by retired Justice Cecilia Muñoz Palma. And I'm happy to tell you that there were 2 Cebuanos who were among the commissioners appointed by President Cory Aquino. One from the South, and that is retired Chief Justice Hilario Davide. At that time, he was not yet appointed justice. No? And the late Regalado Maambong. So one Maambong representing the north of Cebu, and Davide representing the south of Cebu, from our town in Argao. No? Okay, so the topic we are going to tackle tonight will center on the labor relations rights in the Constitution, particularly the right to self-organization, the right to collective bargaining, the right to peaceful concerted action, and the right to participate in policy and decision-making in all matters that relates to the rights, welfare, and benefits of workers. I am going to discuss a very important case, the case of Philippine Airlines, which is a landmark decision by the Supreme Court on the boundaries, the scope, and the limitation of the right to participate. I hope that you will be able to grasp the philosophy and the rationale of this right, which for the first time in our history has been enshrined in the Constitution, not just in the Labor Code, but in the Constitution. So labor relations is anchored on also on another provision of Article 13, which is the mandate given to the state to regulate the relations between workers and employers. If you remember the Civil Code of the Philippines in Article 1700, there is a provision that says that the relations between capital and labor, nauna pa ang capital doon, the relations between capital and labor is not merely contractual. It is imbued with public interest. Therefore, the state, in the exercise of police power, has the inherent right to interfere in the relationship, to interfere, and perhaps even in the process of interference may sacrifice some of the prerogatives of management or even the rights of the employee. So the state, in the exercise of police power, has the overriding authority to insist on its decision, which may contradict or even negate the right of an employee on the one hand, or the prerogative of management on the other hand. So this is going to be a very exciting discussion, because I always say, Dr. Velasco, I always say this, the relationship between employee and employer is like husband and wife. And the state, the government, is the mother-in-law. The mother-in-law is always interfering. Di ba? Ang papel ng mga ugangan, manghilabot. And that action, pagpanghilabot, is inherent in a state, because in the language of Justice Laurel in Kalalang versus Williams, this is the state trying to equalize the forces in society and to level the playing field, as well as to equalize the forces in society and to humanize the laws through the enactment of measures that shall promote the general welfare of the people. So the state is therefore authorized by virtue of its inherent power to interfere in the rights of employees and employers. So in the event that employees and employers collide with each other, the employee with his rights and the employer with his prerogative, for instance, the prerogative of the employer to hire and fire, that is on one hand. On the other hand, the right of the employee to security of tenure, that will collide, because once an employer exercises his authority or prerogative. I'll give you an example. I have a client, San Miguel Corporation, shipping and transport, shipping and lighter rates. which is based in Mandaue. It has employees working in the port area because all the products of San Miguel, like beer, like packaging, like Monterey products, and all the San Miguel group of companies, they are being transported from island to island. So there are 3 employees in Mandaue who wrote management that they are refusing the order of management for them to undergo a swab test. But the expense is charged to management. Employees do not have any expense, but they are required because they are handling very sensitive commodities like foods. And so we are going to protect not only the customer, but also the other employees. So the company came up with an instruction in the exercise of its management prerogative to lay down policy. Management came up with this instruction. And here comes the employee willfully disobeying this instruction. Now, the reason of the employee is that they have read somewhere from the Department of Health issuance that management cannot terminate the services of an employee who refuses to undergo a swab test. Well, in the first place, the Department of Health is not the proper agency to make a statement about termination of employment. And so the position of management is if and when these 3 employees would persist in the refusal, that would constitute as a willful disobedience to a lawful order given by a superior in relation to work. And if you read Article 297, which is Book 6 of the Labor Code, that is insubordination, which is a just cause to terminate. So, just to give you an example, the employer may exercise the prerogative to terminate after due process, no? And the employee will insist on security of tenure, so there is now a conflict between security of tenure and prerogative. And here comes the state acting through the NLRC or the Department of Labor, trying to regulate and makes a decision. That is what I am saying, that the relationship between the employer and the employee is not merely contractual. In other words, it is not just the written agreement that will govern the relationship, but it is the law. The law takes precedence over the contract. That's why in Article 295, which used to be Article 280, before it was renumbered, there is a provision that says the written agreement, the written provision of a contract to the contrary notwithstanding, and regardless of the oral agreements of the parties, and so on and so forth. In other words, even if the parties have the freedom to contract, to freedom to stipulate, it is the will of the state that will govern, not the stipulation of the parties, because the relationship between labor and capital is not merely contractual. It is imbued with public interest, which therefore means that the state can interfere, even if the state is not being invoked. Even if the state, kahit one of the parties did not ask for the interference of the state on its own, motu proprio, can interfere. That is exemplified by the visitorial power of the Secretary of Labor under Article 128. Even without a complaint from the employee, the DOLE, acting in behalf of the state, can come into the company, examine the payroll, look at the books of account, interrogate some of the employees, looks around for issues on health and safety, and based on his findings, without any hearing, submit to the regional director, and the regional director can issue an order for compliance. And if you receive an order of compliance, you have 10 days whether to comply or to appeal. And if you appeal, you have to attach a bond, cash bond, or a surety bond issued by a reputable bonding company accredited by DOLE. That is an example of the state interfering in the relationship. And we will have a series of cases of interference. So as you can you see this from your screen?
Yes, attorney.
Okay. You will see all the rights. All the rights, you will see right number 1, security of tenure, that's labor relations. Right number 2, self-organization, that's labor relations. Right number 3, collective bargaining, that's labor relations. Right number 4, just and humane working conditions, that's labor standards. Right number 5, the right to peaceful concerted action, including the right to strike in accordance with law, that is labor relations. Number 6, the right to participate in policy and decision making in all matters that relates to their right, welfare, and benefits. That is labor relations. Number 7 is just share in the fruits of production, that is labor standards. And all the rest, labor standards. On the other hand, the prerogatives of management to hire, fire, transfer, promote, demote, lay off, lay down policy, discipline, work, establish working hours, to rearrange working hours. You can even arrange the working structures during the COVID pandemic. You can ask your employees to work from home, or you can compress the work week. You can have a blending between work from home and work in the office. These are all the prerogatives that is allowed by law for management. And then sell the company, merge, consolidate, stop, and close. Can you imagine my other alma mater where I studied in high school and AB, Southwestern University, was sold. And it could have been, it was never imagined by the founders, the Asnars, Don Matias Asnar II and Doña Anunciación Barcenilla Asnar, that the grandchildren would sell the property, no, to FINMA. Although, of course, the children of Dr. Lydia Asnar Alfonso did not. So they retained their shares of stock. That is the only family that I think did not sell out. But anyway, this is a prerogative of the company. The company can merge, can consolidate, just like what happened to BPI and Far East Bank. They consolidate, they merge. Allied Bank and PNB consolidate. And PCI Bank consolidate with BDO, and so on and so forth. These are prerogatives of the owners. But in the process of doing that, they may trample on the rights of the employees, like rights to security of tenure. That's why the Supreme Court in the case of Bank of PI versus NLRC, decided by the Supreme Court in Bank with Justice, the former Chief Justice as ponente, decided that the security of tenure of the workers cannot be left in a limbo. They should be assured, which therefore means that the surviving company, the BPI, should absorb all the employees of the non-surviving company, which was Far East Bank. I'm just trying to illustrate to you conflict between rights and prerogatives. But you know, prerogatives are not provided in the Constitution, while rights are enshrined in the Constitution. The only rights of the employers in the Constitution are the right to reasonable return on investment, the right to growth and expansion in Article 13, Section 3. But on the other hand, all the rights of the employees are enshrined in the Constitution. It is not just in the Labor Code, but in the Constitution itself. Management prerogatives can be derived from the law on property in Book 2 of the Civil Code. One of the attributes of ownership of a property is the right to use your property and to manage your property. And therefore, if you own the business, that is your property, you have the right to manage your business. Manage your business. And since you own the business, you have the right to determine who will manage your business. So the owners have the prerogatives because of their ownership. In other words, the prerogative to hire and fire emanates from the right of property ownership. And if you are management, you are delegated by the owners the prerogative. You derive your authority to hire and fire, to discipline from the owner because they own the property. Yan ang sinasabi ko na he who owns the property has the right to determine who will manage the property. No? Kung sino ang may-ari ng isang pag-aari, siya ang may karapatan na mag-decide kung sinong pahawakin niya sa kanyang pag-aari. Tama ba yung Tagalog ko? Bisaya ako eh. So, ang pag-aari ay property. Ang paghawak ay manage. Kasi ang word na manage, nanggagaling yan sa Latin na manus, hand. So, kung hinahawakan mo yung pag-aari ng iyong kapwa, you manage the property of your fellow man who is the owner. So pwede mong sabihin sa boyfriend mo na, pwede bang hawakan mo yung aking pag-aari? Ibig sabihin, can you manage my property? Tama ba yan, Attorney Wagas? Na sabihin mo halimbawa sa boyfriend mo, can you manage my property? Sa Tagalog niyan, pwede mo bang hawakan ang aking pag-aari? At is, can you manage my property? Because managing my property is part of a prerogative that I am delegating to you by virtue of my ownership. In other words, my friends, all the prerogatives of the employers are prerogatives because of property rights, while the right of the employees are vested on them by the Constitution. And job security is not just a property, it is life. Diba? Sa Bill of Rights, no person shall be deprived of his life, liberty, or property. Hierarchy yan eh. Ang pinaka-importanting right ay life. You can waive your right to property. You can waive your liberty, but you cannot waive your life. And livelihood is life because kabuhayan yan, hanap buhay, panginabuhi, busa kung gitangtangan nimo og panginabuhi, ang usa ka trabahante imo siyang gitangtangan og kinabuhi. Kay ang iyang pamilya dili na mabuhi. Busa, that is how important is security of tenure. That is how important are the rights of the workers. And that is why the state is mandated by the sovereign Filipino people to afford full protection to labor. local or overseas, organized or unorganized. Ganon kabigat ang diin, ang emphasis ng Estado pag-protect sa mga katungod sa mga manggagawa. Ganon yan. Tatlo yan. Labor needs social justice. Capital needs profit. The state wants industrial peace based on justice, and they are mandated to protect labor but not to oppress capital. Yun naman ang sinasabi. And so labor relations, ladies and gentlemen, if you look at the term labor relations, it's plural. It's plural yan. Bakit? Because it is not just the employee and employer relations. It is also the relation of the employee and the union. It is also the relation of the union and the federation. It is also the relation between the employee and the state, and the employer and the state. For instance, the employee forms a union. This staged a strike, and the employer is engaged in a vital industry like transportation. And the state, therefore, exercises the power to assume jurisdiction over the dispute that caused the strike, because what is involved is public interest. Therefore, the state can stop the strike by the mere assumption of jurisdiction exercised by the Secretary of Labor, which is also a form of police power. The moment the Secretary of Labor assumes the jurisdiction and the union is notified, from that moment the strike should stop. If you remember, Dr. Velasco, there is a hospital along Jones Avenue near the Bradford Church. It is a hospital owned by the religion of Dean Hormachuelos, if you remember that. There was a long strike. Do you remember, Dr. Velasco, that there was a very long, protracted strike in that hospital? So, how did the Department of Labor resolve that dispute? Through arbitration. Through arbitration, because the employer and the employee could never reach an agreement. It is the mother-in-law, which is the state, that takes over and resolve the dispute. And that is the exercise of police power. Even if you have the right to strike, and you, employer, also, you cannot dismiss all of the strikers. The state enforces the law that only those who committed illegal acts like violence, intimidation, obstruction of ingress and egress, only them, when there is a very specific and convincing evidence pointing to a specific employee. You cannot terminate on a blanket termination, a general termination for all. No, because the state also protects security of tenure. And while the state also tries to bring back the peace in the hospital, it is also the duty of the state to make sure that the workers' security of tenure are not sacrificed or is not sacrificed. Now, can you see this? Can you see this illustration, Mr. Carion? Can you see this?
Yes, USEC.
Makita ninyo yan. This is not the solar system. Makita ninyo, I am the only professor in the whole Philippines who prepares a visual representation of the metamorphosis from person to litigant. No? When you are born into this world, you are a person upon the age of 15. Why do I say 15? You look at Article 137 of the Labor Code, Book 3. The minimum age of employment is 15. You can be employed at the age of 15, but not in hazardous operations. So when you reach the age of 15, you become a worker. You belong to the labor force if you are not studying. And once you enter into an employer-employee relationship, you become an employee. Nakita ninyo ang arrow pataas. So the higher you go, the more rights you enjoy. And when the employee joins a union, number 4, that we will cover that next meeting. All the steps of formation of the unions, what are the requirements, who are included, who are excluded, and all the protocols of unionism, we will cover in number 4. From number 4 up to number 12, that is the coverage of our review. So every number there is one meeting. We will have one meeting, next meeting about unions. Who are eligible, who are not eligible, what are the protocols, what are the procedures in organizing a unions, what are the requirements. We will review that, and I'll give you a lot of mnemonic device. Don't be absent next meeting. And then LLO is legitimate labor organization. A union that is not registered is not an LLO. If you are not an LLO, if you are not a legitimate labor organization, you cannot ask for collective bargaining. You cannot be considered a juridical personality. You cannot own a property. You cannot file a case in behalf of your members. Therefore, it is important that you must be registered. The KMU, Kilusang Mayuno, filed a case before the International Labor Organization based in Geneva when I was still undersecretary. KMU was accusing the government of the Republic of the Philippines of violating its own constitution by requiring registration as a condition precedent to the exercise of the right to collective bargaining. It is the submission of KMU that the right to join, assist, or form unions is an inherent right, and there is no need to register to be able to exercise this right. And therefore, KMU was saying government violates the provision of the Constitution that says in the Bill of Rights that the right to join associations, unions, and societies shall not be abridged. And by requiring registration as a condition, it is a form of abridging. Well, I was the one sent to Geneva to argue for the government. I was with the Solicitor General. The Solicitor General was a very good lawyer, but he was not a specialist in labor law. So I argued before the magistrates in ILO, and I told them that the petitioner KMU intentionally omitted a phrase in the Bill of Rights, the provision of the right of the people to join associations, unions, societies. There is a phrase, for purposes not contrary to law. Therefore, the grant of the right or the freedom of association and the right to join unions is not absolute. The state has made a reservation that the purpose of joining unions must not be contrary to law because the state has the inherent right and power to defend itself. It would be an irony if unions would be allowed to operate within the territorial jurisdiction of the Republic of the Philippines, Your Honor, and yet some of these unions have the prime objective to put the country under the control and domination of an alien power. Therefore, it violates the very essence of its sovereignty. It is therefore the right of the state to require registration as a condition for the exercise of the freedom of association. And because of my argument, the magistrate right then and there ordered the dismissal of the petition of KMU. And that's why the KMU does not like me. I am blacklisted by the KMU, but when I was a student and here in UB, I was the president of the Supreme Student Council in 1972. When martial law was declared, I was also detained in Camp Sergio Osmeña for 7 weeks because I was a student activist. And I believe my believitarianism, but I don't subscribe to the communist ideology. And so when I was already in Camp Sergio Osmeña, Governor Eduardo Gullas talked to the commander, General Narcisse, to release Joseph Jimenez because he is only an activist. He is not a communist. So, yung mga sinisigaw niyang ibagsak ang pasismo, imperialismo, misismo, at ikaw mismo ay sigaw lang yan. Wala yan sa puso niya kasi kilala ko yan. Kaya nirelease ako because of the intervention of Governor Gurlias. But sabi ko kay Governor, bakit mo naman ako pinalabas? Kasi enjoy ako sa loob. Kasama ko yung mga taga-Immaculada, taga-Santa Teresa. Sobrang ganda. Everyday, kumakanta kami ng bayan ko, holding hands. So, yan ang aking experience in relation to what I am discussing with you now. That the right to join unions is not absolute. The union must register because registration is the only means by which the state will know whether the purpose of the union is not contrary to law. And it is the power of the state to make sure that all societies, associations, and organizations operating here should not subscribe to any principle that will promote undermining the sovereignty of the state. That is why the anti-terror law, which is now pending before the Supreme Court, there are now more than 35 petitions for the annulment of that law. That will be subject now to the evaluation of the Supreme Court. And the Supreme Court now, members of the Supreme Court are having sleepless nights how to decide this because the government is saying that there are many forces trying to undermine the sovereignty of the state. We have terrorism. We have COVID pandemic. We have so many people who commit inciting to sedition, putting and undermining the power of the state. Well, we will just focus on labor law because that is political law. Now, how does an LLO become a SEBA? A SEBA is a sole and exclusive bargaining agent mainly through the process of certification election. So we will study again the certification election, what is an appropriate bargaining unit, what is the freedom period, what are the closed shop, what are the union shop, what are the requirements for having a certification election in case of runoff, what are the procedures. So I will give you a mnemonic device. Don't worry, it is all stated in my book. No. Now, after the union becomes a sole and exclusive bargaining agent, the union will negotiate with management, and they will come up with a contract called collective bargaining agreement. Collective bargaining agreement, and if and when the company commits unfair labor practice like discrimination in order to discourage unionism or to restrain, interfere, and coerce. Remember yung mnemonic device ko, RIC, restrain, interfere, and coerce. At saka yung IDA. Ano yung IDA? Initiate, dominate, and assist. Kung ang management mismo ang nag-initiate na magtayo ng union, that is also unfair labor practice. Dahil ayaw ng batas makialam ang management pagtayo ng union. Yan ang nangyari sa Divine Word University sa Tacloban. Dahil nung nagtayo ang mga faculty members doon ng tunay na union, ang kabila naman, yung management, ang administration, nagtayo ng sarili nilang union. That's why nagkaroon ng wilga ang Divine Word University at nagkaroon ng assumption si Secretary Laguisma. Ang unang question doon is, did management commit ULP? The answer was yes. According to the Supreme Court, speaking through Justice Florida Roth Romero, former professor of law of UP and legal advisor to President Aquino, who became a justice of the Supreme Court. Florida Roth Romero, kasama namin yung arbitrator ng labor dispute, but she died already. So she was the one who decided Divine Word. The first issue, was the management guilty of ULP? Yes. Number two, was the strike legal or illegal? The answer is the strike was legal because there was a notice of strike, there was a strike vote, the ground was unfair labor practice, and there was observance of the cooling off period. All the requirements were complied with, and therefore the strike was legal. And for failure of the management to answer, to reply to the letter of demand of the union to negotiate, that failure means that all the demands of the union were considered accepted by management. You know, the union there was Associated Labor Union, ALO. ALO yun eh. So ang nakatumba talaga ng Divine Word University was ALO. So where is Divine Word University now? There's no more Divine Word University because it was abolished because the total demands of the union, sabi ng Supreme Court, dahil hindi kayo sumagot sa sulat ng union asking for negotiation, ang lahat ng demand ng union ay considered accepted by management. At pag-compute ng lahat ng demand ng union, that is more than the total assets of the university. But you know, just very recently I discovered a very ironical consequence or circumstance. You know what? The property pala where the Divine Word University was erected was not owned by the university. It is owned by the Diocese of Palo. the Archdiocese of Palo. And therefore, ang inaasahan ng Associated Labor Union na buong mga building, pati yung mga lupa, mapunta na sa alo. Nawala rin. Sila yung nagwagi, pero sila rin ang nasawi. Ganun ang nangyari dyan. That's the tragedy. Because, you know what? Because it was the mistake of the lawyer. If you read the provision of Article 250, the old 250 plus 15, 265, the old provision there is you have to answer within 10 calendar days. 10 calendar days. When the union writes you to negotiate, the management must answer within 10 calendar days. And the answer need not include counter offer. By failing to answer within 10 calendar days, the management was deemed to have committed unfair labor practice. And that unfair labor practice was the ground for filing a notice of strike. That is the story of the Bindward University. And the greatest irony was the ponente, Clarida Romero, was a Protestant, and it was a Catholic school. The owner of the Bindward University is also the owner of San Carlos. That is SVD. So I am very sad about what happened, because what is Tacloban without the Bindward University? It's like, what is Dumaguete without Silliman University? That is the story, because they did not follow a very simple law in labor relations. So we will take up ULP, we will take up strike, then we will take up termination of employment. Dismissal is different because that is Article 297, formerly 282. Dismissal based on just cause, like serious misconduct, insubordination, gross and habitual neglect of duty, fraud or breach of trust, crime against the person of the employer, and analogous cases. That is just cause. And you use the term dismissal when it is the fault of the employee. But when it is retrenchment, redundancy, labor-saving device, retirement, or separation based on disease, do not use the word dismissal. Use the word separation. You do not dismiss an employee because of retrenchment. You separate him. That's why he is entitled to separation pay. You better believe me, because I was involved in the development of the labor code. When I took the bar in 1974, after the bar, I was hired by the Department of Labor, by Secretary Ople, to be part of a group that will write the rules and regulations implementing the labor code. And I was part of that in 1974. Now, 2020, the lower house Congress has gotten my services in order to repeal the labor code. I am now writing the new Magna Carta of Labor. Yan ang maging bagong pangalan natin, the new Magna Carta of Labor. Pag nagawa na itong gibuhat na ako ng labor code, ang tawag niya na Magna Carta of Labor. Gusto sana nilang tawagin na Human Capital Code, pero ayaw ng mga union yan kasi capital, allergic sila sa word na capital. And the last is labor litigation. We will study here compulsory arbitration, jurisdiction ng labor arbiter, jurisdiction ng NLRC, tapos from the decision of the arbiter, 10 calendar days to the NLRC based on grave abuse of discretion or serious errors in the findings of facts, which if not corrected would cause grave and irreparable damage, and then questions of law, and then graft and corruption. Apat lang ang ground for appeal. From labor arbiter, walang motion for reconsideration from labor arbiter to the NLRC. Then from NLRC, motion for reconsideration muna. If denied, go to the Court of Appeals. That is Rule 65, petition for certiorari. Pag na-deny sa Court of Appeals, motion for reconsideration muna, then go to the Supreme Court, Rule 45. All of that we will discuss. No? Lisod ang akong trabaho. Kaya nga sinulat ko na yan dito eh. I will be very happy kung kayong lahat makakuha ng libro na ito. Kasi talagang more than 1,000 pages ito. Lahat ng gusto nyong itanong. Binigyan ko ng kopya lahat ng justices ng Supreme Court, pati si Justice Leonen. Alam ko, kukuha sila ng bar question dyan dahil every year talaga nagbibigay ako sa mga justices. Libre lang yun na pinamimigay ko kasi para naman makita nila na may tagayubi na author. Mga tagayubi, taga-Ateneo de Colon, mga naaday taga-Ateneo de Colon nagsulat og libro. Niya ka ng tagayubi, dilipod mo palit. Pamalit mo kay Aron ma-share na ko ninyo ang kuan kung naapa ko'y kwarta panagaan na mo tanan. Okay, so 28 most important principles. Can you imagine that? 28 most important principles. Isa-isahin ko yan ha. Una ko i-discuss nyo the principle of full protection. Tapos the principle of social justice. Tapos the principle of police power. Yung tatlo na yan. Tapos the principle of self-organization, union na yan. Collective bargaining, peaceful concerted action, including the right to strike, and the principle of shared responsibility between labor and management. The number 8, ayan, na-repeat yung shared responsibility. Preferential use for voluntary modes of dispute settlement, principle of resolving doubts in favor of labor, doubts in the implementation and interpretation of the labor code, including its rules, implementing rules and regulations. Pero doubts in the interpretation of contract, ang gamitin nyo dyan, civil code, not labor code. Kasi labor code, limited lang sa labor code and its implementing rules. The principle against technical rules. Technicalities are frowned upon. What is paramount is substantive justice. The principle of expeditious labor justice. Speedy and inexpensive. Article, that is in Article 218, the first article of the Book 5. It used to be Article 211, now it is Article 218. The principle of stable, dynamic, and just industrial peace. The principle against undue judicial interference in free collective bargaining. In Article 218, it is explicitly provided that the courts cannot issue injunction, cannot issue restraining order in matters that pertains to free collective bargaining. In other words, free collective bargaining should be immune from judicial interference. It's only when rights are alleged to have been violated. But while negotiation is ongoing, while negotiation is ongoing between the union and the management, the court cannot issue a restraining order telling the parties to stop negotiating. That is not allowed. No? Then the principle of protection to labor against greedy recruiters in Book 1. Republic Act 8042 and Republic Act 10022 amending Book 1 of the Labor Code is the illustration of protecting the OFWs from the greed, the very cruel treatment given to our migrant workers. then protection to labor, health, safety, and welfare in Book 4, protection against unfair employers, protection against unjust unions. Can you imagine? You know, later on, I'll tell you the principle of protections. No? Ito, protection. Kung pag-usapan na natin itong protection, usually the students always believe that the state protects labor only against the employer. That is partially correct because the first protection is protecting labor against the employer. Yung mga employer na kahit regular position ginagawang contractual, yung mga employer na nandadaya sa minimum wage at saka sa overtime pay, lahat na yan, they cannot escape from the protection of the state because there is a visitorial power from the Secretary of Labor. There is the power of adjudication by the NLRC. So, these employers should better be careful because the state is watching. The state is watching from hiring to retiring, from hiring to retiring, from crib to grade. The state is watching over the workers. No? Yung mga illegal dismissal, unfair labor practices, unjust discrimination, constructive dismissals, these are all the evil that are sought to be avoided. That's why the protection to labor is in the form of many provisions in the labor code, including the doubts should be resolved in favor of labor. Yung mga quit claim na gawa-gawa ng mga employer na hindi naintindihan ng employee. Number 2, ito yung hindi ninyo in-expect. If the union is the protector of the employee against management, what happens if it is the union itself that commits injustice against the employee? In other words, parang sinabi, kung ang pulis protector ng mga tao, niya kinsa may mo protect sa mga tao kung ang mga pulis na mismo may abuso sa tao. So, the state, ang answer, ang sagot niyan, the state. Because meron mga union nga collecting outrageous amount of union dues. Unya, asking the company to terminate the services of another employee who is not cooperative with the union. The use of union security clause, close shop, union shop, maintenance of membership shop. Lahat na yan inaabuso ng union. So the state is very careful na ikaw union, you are supposed to be the protector of your members, but you are the ones violating the right of your members. There is a new case that will come out in this coming bar, and that is the case of Manila Peninsula Hotel. And this is about the union, NORAIN, National Union of Workers in the Hotel and Restaurant Industry, NORAIN, increase the union dues without following strictly the protocol. Kasi kung mag-increase ka ng union dues, dapat sundin mo yung very strict requirements ng Book 5. Mag-meeting ka sa union mo, mag-pass ka ng resolution, ilista mo sinong bumoto ng yes, sinong bumoto ng no, tapos you call for a General Assembly so that that resolution of the union should be ratified. You cannot just increase the union dues without ratification because that creates an obligation, and the obligation should be accepted by the employee because sovereignty in the union resides in the members, not in the officer. Sovereignty resides in the people and all authority emanates from them. So kung mag-increase ka ng union dues na wala kang ratification from the member, that increase is null and void. That is ultra virus. That is unauthorized. That is beyond the scope of the authority of the union official. So the state will come in to annul, and that is protection. Protection by the state to the members. So kung mag-away yung union against management, union versus management, papaboran ng state yung union. Pero pag ang kalaban ng union, yung sarili niyang member, that is intra-union dispute, the state will favor the least of the two, which is the union member, against the power of the union. I hope I am being understood by you. Now, number 3, the state protects the workers against government. Because the state is different from the government. The government is just an element of the state. The state is a community of persons, more or less numerous, permanently occupying a territory and having a government with sovereignty to which the great body of inhabitants render habitual obedience. Memorize ko yan. 1972 ko pa memorize yan. Si Dean Gilyamak ang nagpamemorize sa among anak. Definition of the state, the elements of the state. So the state protects the employee from the government. Kung ang mga arbiter o mga commissioner sa NLRC dili magdesisyon within the reglementary period, dugay-dugayon ang kaso. Doon nabita ko i-column karon sa Freeman, basahin ninyo ng column ng Freeman karon og ugma hasta sa Merkulis. Tungkol yan sa isang Cebuano na tinanggal ng Lufthansa. Kanang Lufthansa, maunay technical arm ng PAL. Yung PAL kasi, dati ang PAL, lahat ng mga maintenance nila sa aeroplano, mga mekaniko, empleyado ng PAL. Nung nauso na yung contractualization, outsourcing, mga taas kaig sweldo ng mga mekaniko, gi-outsource na nila, gi-retire tanang mga mekaniko, gi-retire o niya, gi-absorb ining bagong kumpanya nga Lufthansa, European company. Tapos, ina-outsource yung tanang maintenance ng PAL, ang Lufthansa mo yung magtrabaho. Niya kaning empleyado taga Cebu, gi-terminate sa Lufthansa ang ground loss of trust and confidence o gross and habitual negligence. Pag file sa kaso sa arbiter, pilde ang trabahante, kadaog ang management. Gi-appeal sa NLRC, daog hapon ang management. Pag abot sa Court of Appeals, naharap ba diya si Justice Gabi English, dating dean sa San Carlos. Amigo na ko na. Friend na ko na sa Facebook, pero parting buutana ng tawanan. Pag abot sa Court of Appeals, gi-reverse ang desisyon sa arbiter o NLRC. Niingon ang Court of Appeals. Management failed to prove the basis for loss of trust and confidence. Management failed to establish gross and habitual neglect of duty. So, the state now, acting through the Court of Appeals, is protecting the employee from the grave abuse of discretion of the lower labor tribunals. So, the state shall afford full protection to labor. And this writ of certiorari is a form of protection. No? Kung wala tayong ganon, wala na. Zero na itong 22 years in service na ba ito? Masiro na lang ito yung service. Karon, parting dakuak, mga makadawat siguro o mga 12 million pesos. Usa lang na ka worker. Sa back wages lang kasi from the time na dinismiss, ang niabot nag mga 7 ka tuig hangtod sa Supreme Court. 7 ka tuig niyang sweldo. Nataas man tog sweldo. Kay senior naman to siya. Tapos kanang 7 ka tuig i-multiply nimo 13 months kasi na may 13 month pay. 7 times 13 months. Tapos kung ang sweldo niya mga 100,000 a month, dako na kayo. Pagkatapos meron pang retirement pay or separation pay, whichever is higher. Tapos on top of that, and you have to remember this, ladies and gentlemen, when you take the bar, the decision of the Supreme Court in Macario Nakar versus Gallery Frames, 6% interest per annum on all monetary award. Lahat ng monetary award, from the time of finality of judgment up to the actual satisfaction of judgment, they will pay 6% per annum compounded annually. Tapos, meron pang 10% attorney's fees. Maayo gani kay walay moral damages eh. So that is the state protecting labor against the government. Now, itong the state protecting labor against the lawyer. Because, you know, there are lawyers who do not follow the provision of Article 110 or 111 of Book 3 na only 10%, of course, that is for money claims. Pero usually talaga ang ina-award ng Supreme Court not only in money claims but even in illegal dismissal is only 10%. Yung mga abogado manghihingi ng more than 10%. Manghihingi ng 20%. Yung iba nga hati-hati pa, tunga-tunga, magkano matanggap ng empleyado, hatiin nila. So in the case of Wilfredo Taganas, this is legal ethics. I'm also teaching legal ethics. The Supreme Court disciplined the lawyer, Wilfredo Taganas, for entering into a written contract with the client that whatever will be awarded would be divided by 2 between the lawyer and the client. Of course, the client later on complained because this is so much. So the Supreme Court disciplined the lawyer, and this is a form of protecting the employee from unethical lawyers. Ang panghuli, ito pinakamatindi. Protecting labor against labor. Yung mga workers na pumipirma ng resignation na hindi nila iniisip, mga quit claim, waivers, release, at tapos prepared by some lawyers, and hindi man lang niya naintindihan yung pinirmahan niya. Remember, my friends, that while as a general rule in the civil code, compromises are encouraged to settle disputes. But since compromises are also forms of contracts, from compromise agreement, the elements of contract should be present, namely consideration, object, and cause. Cause, object, and consideration. Consent, object, and consideration. Consent is very important because if there is a vitiated consent like undue influence, moral ascendancy, pressure, deceit, gross misrepresentation, intimidation, force, coercion, this will vitiate the consent. and the other is consideration. If the amount that is granted to the employee is shocking to the conscience of every man, shocking to the conscience of man, that will be declared null and void because that is contrary to law and public policy. And so, ladies and gentlemen, I have demonstrated to you that the state protects labor not only against the employer, but also against the union, against the government, against unethical lawyers, and even will save labor from labor's own ignorance, lack of foresight, and lack of skill, labor's own absence of sufficient knowledge on the nuances of contracts. Bakit kailangan may witness ang contract? Para yung saksi, mubarog siya nga kanang tao nga ni perma sa usa ka kasulatan, nasabtan niya. You know, when I was studying in UB, I was a court interpreter. So kung doon na nga compromise agreement, moingon na to si judge, kay kato si judge akong amo, professor man to sa San Jose o sa San Carlos. Stricto ka ito, si Judge Inclino. Moingon to siya, Josephus, you explain to them the far-reaching consequences of signing a quit claim. So usahay pag sa pagkamaayo na ko pagpasabot sa tao, dili na noon mo perma ang tao, nasuko ng abogado na ko. Giunsa man mo pagpasabot, Josephus, nga nagsabot naman ang daming mo perma sila, withdrawal niya, karon di naman ang perma. O ako lang gibuhat ang akong naibawan, no? Nga kaning mga tao nga mo perma sa ilang contract, ipasabot gyud ninyo, no? Bago ka mo perma og contract. Kamo naminaw nako, perma mo contract. Mga abogado ra ba mo nya dili ug mukiha mo, di mo tuhuan nga you are a lawyer, you are a graduate of law, and you do not understand what you sign. Mao mo ta pagkasal na ako, nadugay gyud kay ako yung gibasag maayo sa wa pa gani ito nako permahe dito mo to sa Sacred Heart ko kasla nya si Gobernador Gulyas ra ba, si Idigol ra ba ninong nako nya nganong gadugay-dugay man kag perma Josephus. Ako ning gitan-aw ning kontratahag, do na ba ni expiration o do na ba ni kuan, do na ba ni condition o do na ba ni mga provision on settlement of dispute. So kung na inong pare, kaya kung naay sunod nga ikasal, nga dugay-dugayon nimo, perma na lang ko eh. Okay. So I hope that I was able to explain to you the 5 dimensions of protection. Ito pa, dagdagan pa natin. Protection to labor from hiring to retiring, even after death. Bakit? Can you imagine the state protection even when you are already dead? Because your widow will receive the death benefits. And if the death is in connection with your work, in other words, work-related accident, when you meet an accident while you are doing an official function, the state insurance fund will answer, and your beneficiaries will get the rightful indemnity for your death. So the state's protection is beyond your grave, not only from grave to grave, but even beyond. Whether you are a pineapple plantation worker in Bukidnon or a clerk in Makati, you are protected. Whether you are a casual worker sweeping the floors of a condo in Ortigas or a professor in a small college in Bungaw, Tawi-Tawi, both of you enjoy protection. Protection regardless of whether you are a contractual messenger in Tugigaraw or an HR assistant in Cebu City, you have protection. Whether you are a PWD call center agent working in a BPO company in Libis or in Lahog, or you are a sexually abused domestic helper working 18 hours a day in Kuwait, you enjoy protection by your state. And it is only in our state that such protection is available to our workers because, ladies and gentlemen, I tell you, the Philippine Constitution is the only constitution in the whole world, not even US Constitution, has enshrined the rights of labor, not just in the labor code, but in the Constitution. It will require a constitutional amendment to erase these rights. Whether you are a child actor doing a TV commercial, or you are a construction worker, whether you are a gay working in a beauty parlor, or a lesbian working as an erection engineer, constructing the rigs in the borders in the West Philippine Sea, you enjoy protection. You enjoy protection whether you are a seasonal worker in the Hacienda in Negros, or you are a junior executive in the industrial parks in Laguna. You enjoy protection. Whether you are a Pacquiao worker or a fixed-term professional working in a big law firm, you enjoy protection whether you are a seafarer, a marine officer on an ocean-going vessel traversing the Atlantic Ocean, or you are a nurse attending to a COVID patient, you enjoy protection. Alam mo, ang dami kong sinasabi dito. Gusto ko lang i-emphasize sa inyo na protection to labor is all-encompassing. Ang protection natin sa Book 1, pangutanon mo sa bar examiner, how does the state protect labor in Book 1 of the Labor Code? All our laws against anti-illegal recruitment, all the provisions of the Migrant Workers Act 8042 as amended by 10022. Yang provision ng Article 34 and 38 of the Labor Code about syndicated illegal recruitment or in large scale, which is tantamount to economic sabotage, that is protection. At ang penalty niyan ay life imprisonment plus at least 1 million. Hindi yan or, ha? It is and. Life sentence and fine of 1 million. Kita mo? Protecting labor from non-resident aliens. You should remember Article 40, Book 1. The Dole Regional Director cannot issue an alien employment permit to a non-resident alien if there is a Filipino who is willing, able, and competent. Willing, able, and competent to do the job. Kaya pag pinablish yung mga vacancy na gustong kuhaon sa mga Chinese, sa mga Taiwanese, Korean, Japanese, German, i-publish yan sa Sunstar o sa Freeman, i-publish yan sa local newspaper. Ang purpose niyan para kung doon ay Pilipino na gustong mo object, mo file ng opposition, sinubukan ko na yan sa UE. Lahat ng estudyante ko, inutusan ko mag-file kayo ng objection. Kung kaya ninyo yung mga pinablish dyan sa dyaryo, nilagay dyan sa Philippine Star at saka sa Inquirer, na naay mga trabaho sa Laguna, sa Cavite, kaya na ninyo, you are able, mag-file ka mo ng objection. Para lang sa assignment, sa labor standards. Tapos pinatawag sila sa regional director. Sabi, ngayon lang nangyari, ang daming nag-object. Sir, assignment ito ni USEC Jimenez. And kayo ba, competent kayo? Yes, sir. Able ba kayo? Yes, sir. Willing ba kayo magtrabaho? Hindi, sir, kasi estudyante kami. Ba't kayo nag-file ng objection? Just to to emphasize that the Filipinos have the right to object. You know, the leading case here is the case of General Milling. Alam ito ni Attorney Badwilli. General Milling. Si Attorney Badwell kasi ang counsel ng General Milling. Kana si Tim Cohn, siya ang coach ng Alaska. Ang Alaska team is owned by General Milling. Alam ba ninyo yan? General Milling is the company. The team is Alaska because Alaska Milk is owned by that Oitingso family. Oitingso family. So, ito si Tim Cohn, non-resident alien at that time, nakakuha ng alien employment permit sa regional office. Nung nalaman ng mga Pilipino na mga coach, nag-question sila, binasa na yung Labor Code, Article 40. Why give that job to a foreigner when there is a Filipino who is able, willing, and competent? So they question that before the Office of Secretary of Labor, Ruben Torres. And indeed, the Secretary reversed the order of the regional director and gave an order that the alien employment permit of Tim Cohn should be canceled. And Tim Cohn, through General Milling Corporation, went to the Supreme Court, alleging that Secretary Ruben Torres committed grave abuse of discretion amounting to lack of jurisdiction in his act of cancellation. And how did the Supreme Court rule on that? You should know that the Supreme Court upheld the validity of the decision of the Secretary of Labor and said that that was a valid exercise of police power. It was in accordance with the provision not only of the Labor Code, but also of the Constitution that expresses preference for Filipino labor. Preference for Filipino labor. Even, ladies and gentlemen, even if we are now in a globalization, we have opened our borders to other nationalities in the same manner that they have opened their own territory to Filipinos working there. But our law is very clear that we will allow a job to be manned by a foreigner, non-resident alien, only if there is no Filipino who is able, willing, and competent. Tatlo able, willing, and competent. Kasi you may be willing. So you must prove your competence so that you will be given the job. So the Secretary of Labor is a very powerful official of government. He can cancel the alien employment permit, and that cancellation was upheld by the Supreme Court in the case of General Milling Corporation versus Secretary of Labor Ruben Torres. And that is a landmark case until now. That has never been abrogated by the Supreme Court. Protecting labor under BOCTO by skills development. Because the most vulnerable sector among our migrant workers are the domestic helpers because they do not have the skills. The mandate of TISDA is also a mandate of protection. we should send our migrant workers who are highly skilled, competent, so that they can compete in a very tight market situation in the global arena. So the best protection that we can give to the Filipino is skills training. Kasi ang mga highly skilled na mga engineer, mga doktor, wala tayong problema sa mga OFW yung gano'n. Pero ang problema natin dyan sa mga unskilled, kasi yan ang binibigyan ng trabahong 5D. Alam niyo yung 5D na trabaho? Dirty, difficult, dangerous, degrading, and deceptive jobs. Yan ang mga term ng ILO ha. ILO, nag-umpisa lang yan sa 3. Dirty, difficult, and dangerous. Pero ngayon, nadagdagan yan ng degrading at saka deceptive. Yung mga deceptive, pareho ng kaso ng illegal recruitment at trafficking ng isang babaeng minor de edad na dinala ng recruiter sa Labuan Island sa Sabah at doon ginawang prostitute. Ang pag-recruit sa kanya very deceptive kasi sabihin entertainer, hospitality, pagdating doon prostitution. That is deceptive. And that is degrading to the dignity of the Filipino woman. That's why the state protects labor against these greedy traffickers and illegal recruiters who are making money out of the honor and dignity of the Filipino women. Yan dapat parusahan ng death penalty, yung mga illegal recruiter. Pabor ako ibalik ang death penalty. Una, yung mga drug lords. Pangalawa, yung mga nagnakaw ng pera sa PhilHealth. Pangatlo, yung mga illegal recruiters, traffickers. Yan ang dapat patayin. Pero yung nagnakaw lang ng usa ka buok puso sa carbon, nagnakaw ng sardinas sa Talisay, muna yung bilangguon, mangita lang yung tao, mabuhi siya. Nagnakaw, bilyon-bilyon ninakaw sa PhilHealth. Occupational safety and health. The state insurance fund, the employees compensation system for disease, disability, and death. These are protection to labor at the most difficult times of the lives of labor when they are sick, they are disabled, and when they die in line of duty, arising from and in connection with the performance of their official duty. Protection to labor pa rin yan. Protection to labor by promoting unionism and collective bargaining. Because when the workers are unionized, they are strong, they can negotiate for better terms and conditions of employment. And when they are alone, they will just rely on the minimum wage. So unionism is also protection to labor. Providing an adequate administrative machinery. The NLRC is an administrative machinery. It is not a judicial machinery. That is why technical rules are not binding. Even non-lawyers can appear if he represents himself or he represents an organization with authority to represent. Non-lawyers can appear. When a complainant files a case, he does not have to be assisted by a lawyer. Because the government wants to make it easy for the worker to seek redress for grievances. Not making it difficult. Kaya walang filing fee. Mag-file ka ng labor case, may filing fee ba? Wala. Walang filing fee. Merong appeal fee. Kung ikaw, management ka, natalo ka sa kaso, mag-file ka ng appeal bond. Pero pag worker matalo, mag-appeal, walang appeal bond. Does it violate the Equal Protection Clause? Well, in the first place, the employers do not need protection. It is the workers that need protection, and the mandate of Article 13, Section 3 is the state shall afford full protection to labor. Walang protection to management. Although, of course, the Supreme Court always reminds us that protection to labor should not mean oppression of capital. We should not kill the ghost that lays the golden egg. Kasi kung magsara na ng mga employer, wala na rin maging empleyado. So now, it's very easy to form a union. Mayroon nagtanong, Attorney, ilang tao ba kailangan para mag-form ng union? Ang sagot dyan, alam naman ninyo 20% of the total members of the bargaining unit. Hindi to 20% of the total employees. Ha? Bakit? Kung may 15 employees ka, yung dalawa manager, yung dalawa supervisor, yung isa confidential, yung 5 na yan, hindi na yan counted sa bargaining unit. Ang bargaining unit, 10 na lang. So, pag sinabing 20% of the bargaining unit, 2 tao pwedeng mag-form ng union because out of 10, 2 is 20%. They can form a union. The law does not say that the union must have at least 10 members. Only if you have 2 in the bargaining unit, you can form a union. And now, the federation can issue a charter. Para itong Toastmaster Club, Attorney Wagas, Toastmaster Club will issue a charter to the local. Then the local will acquire a juridical personality by the mere issuance of a charter, but that juridical personality is just limited for the purpose of filing a petition for certification election. It is not for the purpose of owning a property and exercising property rights, but it is only to facilitate, expedite, and speed up the filing of certification election. Tamo, ang gobyerno ginawa talagang easier na ngayon magtayo ng union. Dati, ang union madali lang makancel ang certificate of registration because there were so many grounds for cancellation. Yung hindi nag-submit ng official list of members, hindi nag-submit ng audited financial statement, hindi update ng kanilang mga addresses ng mga officer, tanggal na kaagad. Or nag-enter into a sweetheart CBA, yung CBA na disadvantageous to the employee, yung mga union na nabili ng management na gumagawa ng mga CBA na walang benefits, magiging matawag niyan sweetheart CBA, yan ay maging ground sana yan for cancellation. But now, there are only 3 grounds for cancellation. Una is voluntary dissolution. If the people themselves decide to dissolve, in a general assembly, they pass a resolution that will authorize the dissolution of the union. O pangalawa, yung misrepresentation in the adoption of the Constitution and bylaws. Pangatlo, yung misrepresentation in the election of officer. Yung nag-meeting na walang quorum, pagkatapos kunwari nag-elect, those are deceit, those are misrepresentation. 3 lang. at saka voluntary dissolution. Very, very difficult na ngayon to dissolve, but very easy to organize. The labor code was amended first by Senator Boy Herrera, Bisayan yan, and another later on by a group of progressive party list representatives, making chartering as one of the modes of organizing a union. And we will discuss that in details next meeting. Now it is ULP for management to refuse to bargain. It is unfair labor practice for management to refuse to bargain. And the workers are allowed to strike on the ground of unfair labor practice. The Secretary of Labor has visitorial power to make sure that members of the union are not taken advantage of by their own union. And tripartism now is a part of our policy, meaning that workers should be represented in all agencies that are policy making. POAA workers are represented. OWA workers are represented. SSS, PhilHealth, Pag-ibig, workers are represented. Even Land Bank workers are represented. The representation of workers is pursuant to the principle of tripartism, which is an institution we borrowed from the International Labor Organization. If workers are represented, the employers also are represented, and the government. So tripartite. That's why the symbol of DOLE is a triangle: labor, management, government. And they have three missions. One is employment, second is workers' protection, and the third is industrial peace. Another agency with tripartite representation is the Regional Tripartite Wage and Productivity Board, where the employers and the workers side by side, with the regional director of DOLE as chairman, and the assistant chairman is DTI, regional director, and NEDA. There are two of them assisting the DOLE, and the two representatives of labor and two representatives of management. They are the ones deciding what should be the minimum wage for every region, like in Region 7. So that is also part of labor relations, because representation of the workers in government agencies are pursuant to the principle of tripartism, which is a labor relations principle. And defining regular employment, casual employment, seasonal. You know, do not go to the bar examination without really understanding and memorizing the meaning of regular, casual, seasonal, project, lahat na yan, fixed term. Remember the case of Brent International School versus Ronaldo Zamora. All these things, they are protection to labor. So, the case of Globe Mackay is an old case in bank, also decided by Justice Romero. This is upholding security of tenure as the most important right of labor, security of tenure. Before the labor code, there was no security of tenure. Every employer has the absolute right to fire a worker even without cause, by just giving him separation pay. But upon the effectivity of the labor code, security of tenure as enshrined in the Constitution of 1972. Marcos had a constitutional convention one of the delegates, or there were 7 delegates from Region 7. One was Hilario Davide Jr. There were many other delegates, including a priest, Father Flores, and also the son of Congressman Sousa, Francis Sousa. They were delegates. Also, I think Marcelo Fernan was also a delegate. 1972 Constitution. So, Davide was a part of the 1972 Constitution and also in the 1987 Constitution. That is a very rare privilege of a man coming from the mountains of Argao to be given the opportunity to write two Constitution. Bihira lang yan. Protection to OFW. When there is the principle of lex luce contractus, that the law of the place where the contract was signed would apply, we adopt the generally accepted principle of international law as part of the law of the land. Because the employer in Dubai or in Kuwait cannot say that your law in the Philippines does not affect me because I am here in my country. But considering that the foreign employer was represented by an agent, the recruiter here in the Philippines, the principal was bound by the act of the agent within the scope of his agency. And the law of the Philippines, being the place where the contract was signed, would apply. And therefore, this is another form of protection to labor. You know, my friends, next meeting, sa out of 28 principle, isang principle lang diniscuss natin ngayon. But next, I will outline to you the details. I'll give you a sample, sampling lang sa mga i-discuss natin sa next meeting. Yung mga unionization, formation of a union. It is in the other slide. Don't worry, I always prepare. When I come to class, I am always prepared. These are metamorphosis from casual, project, provisionally, regular, then from rank and file, supervisory, confidential, managerial, executive, and board of directors. I outline everything from union to legitimate labor organization to sole and exclusive bargaining agent up to CBA party. Complainant, respondent, appellant, appealee, winning party. We will discuss everything. We have a lot of things to cover. No? So be sure to come again. I thank you, especially those who are not from UB who are attending tonight. Attorney Wagas, you have a lot of visitors. You have to serve coffee now. After our webinar, we have to serve coffee. Virtual coffee lang.
Let's have virtual coffee po.
So, do you have any question? You can unmute yourself and ask question. I will entertain even for additional 5 minutes or 10 minutes. Wala na.